Thanks very much, everyone. Well, I think if we're ready to go, I might now invite Travis Mitchell to talk to us about the particular challenges of the preparation of expert evidence.
Thanks everybody for coming along this morning. There's three things that I'd like to do today, and the first is to very briefly spell out really the ground rules in getting admissible expert evidence together, and I'm sure most of you are familiar with them, so I'll pass over that quite quickly. Then I want to give you 5 ways that things can go wrong, 5 things to do that will make sure that things go wrong, and along the way I'll give you some examples of how it's gone wrong and how bad it can look at the end. The latest decision of the High Court dealing with the opinion evidence rule is the decision of Das Reef Proprietary Limited and Horchart, and it's worth reading because it contains a really pithy summary of the relevant principles. Is that better? Contains a really pithy summary of the relevant principles for having experts give evidence, because the starting point is under the Evidence Act, opinion evidence is not admissible. You then have an exception to that if your evidence is firstly relevant to a fact in issue, obviously. It needs to come from a person who has some specialist knowledge. The specialist knowledge needs to be based on their training, study or experience. And the opinion that's expressed has to be wholly or substantially based on that specialist knowledge. It's Das Reef, D-A-S-R-E-F-F, and Horchart, H-A-W-C-H-A-R. It's 2011, volume 243, Commonwealth Law Reports, page 588. So that's the framework that you need to put yourself in. So one flaw that often happens is that people try and call expert evidence on matters where it's either unnecessary or unhelpful. So the starting point before you get on the phone and engage an expert is firstly, what is the fact I intend to prove with this opinion evidence? Then think about, do I need to have an expert give an opinion to be able to prove that fact? There are some areas where there's a bit of overlap. So for example, if you're looking at financial statements of companies, and assuming the statements go into evidence, you can probably prove through submission all the things that you need to prove, but it might be convenient to call somebody with some accounting expertise to be able to give a summary of the document. And generally courts are receptive to that, because although you might not need the accountant to be able to put all the relevant evidence before the court, the opinion or the summary about what's contained in those financial statements can often be useful. So if there's an opinion that's needed to be able to prove a fact, you need to look at the question of what specialised knowledge will allow that opinion to be given. And there's some very obvious fields of specialised knowledge that are often used in cases, depending on the sort of case you're in. If you're dealing with building cases, you might have an engineer that comes along and gives some evidence. If you're dealing with medical negligence cases, you might have competent medical professionals talk about the relevant reasonable level of conduct in that profession. For that person to be able to give the Evidence Act says that they need to have their knowledge based on either study, training or experience. So it's slightly broader than the old common law position. And people who have recurrent experience of certain things are now able to give expert evidence. More often though, you'll be looking at somebody with qualifications, somebody who's got letters after their name, they've done certain courses, they've practiced in a particular field for a good period of time, and they've got experience of doing something. You then need to make sure that the opinion that they give stays within the sphere of their competence. What is their specialist knowledge? Are they straying beyond that? And so if you find that you're getting an expert, or firstly, you need to direct your questions to the expert to keep them within the four walls of their specialist training or experience. But if they start to stray outside that area, you need to remind them of the focus of what the evidence should be. And a final preliminary thing before you engage the expert, it's quite useful to just have a look on LexisNexis or on Austlii and see how they've performed previously. There's plenty of expert evidence who have had judgment passed on them in cases, and it's easy enough to just look them up and see whether their evidence has been accepted in the tribunal that you're in, or whether they've done things that perhaps left their evidence inadmissible or viewed unfavourably by the court. And you just need to be a bit wary. Sometimes that might not be the expert's fault. And the decision of Das Reef and Horchar is a very good example where the expert seems to have been sent down the wrong path. Now, there was a great example of an expert trying to give expert evidence outside his area of expertise in a case that I wasn't involved in at trial, but I became later involved in on appeal. And when I was reading through the transcript of this witness being cross-examined, I almost punched the air reading this stuff. And I want to read a little passage out now. Essentially, it was a case where some people had worked for a flooring adhesive manufacturer. They left, they set up a competing business. And so the fact that this evidence was dealing with was the claim being that they nicked formulas and gone and developed products using confidential information. So this expert evidence was directed to how long would somebody as a startup take to develop these kind of products if they didn't have the specialist knowledge that they'd taken with them from their former employer. And so the expert was asked by the instructing solicitors, what's the process that should be followed to develop a product of the nature and complexity of products A and product B? And so in cross-examination, this is what emerged. Now, once again, those are two products with which you had no prior familiarity as at November 2008. Have I got that right? Correct. Did you raise that? Yes. There was a meeting. And as a result of that meeting, did you consult the solicitors? A meeting was arranged with the solicitors. The meeting was presumably held at the office of the solicitors? Correct. Is the substance of the communication from you at this meeting that you personally didn't have the necessary expertise to respond to the question that was being asked of you? Yes. You said that? Yes. What about, did you declare your inability to respond to question 4.2a, having regard to your lack of technical familiarity in respect to the question being posed? Did you raise that at the meeting? Yes. And does it follow from the answer that you gave that notwithstanding your declaration of inability, the solicitors said, bat on, give the evidence anyway? Or not in those terms, but yes. His evidence wasn't given a lot of weight in the judgment. So now my view on reading these sort of cases is that not all of us have the privilege of receiving direct tuition in the laws of evidence from the High Court. So when others have that rained down on them from a great height, we should really pay attention. And Das Reef and Horchar is a great example which really illustrates the principles very well. Mr. Horchar was a stonemason. He contracted silicosis from his work as a stonemason, and he'd worked at various employers. Silicosis is a respiratory disease, and it's caused by exposure to silica dust, which is produced from cutting stone. He sued his employer for breach of various duties that caused the silicosis. Now, at trial in the New South Wales Dust Diseases Tribunal, he called an expert who was a chartered chemist, a professional engineer and a former academic, Dr. Basden. Dr. Basden was provided with some photographs of the worksite, of a plastic tent that Mr. Horchar had been in when he'd been cutting stone on various occasions, of the mask that he wore. Dr. Basden gave an estimate of the amount of silica dust that Mr. Horchar would have been exposed to Now, there was a standard at the time that said you needed to be exposed to less than 0.2 milligrams of respirable silica per cubic metre of air over a 40-hour week. And Dr. Baston said, oh no, it'd be something like 1,000 times the order of that. The trial judge then went and used that, it'd be something in the order of 1,000 times, as the basis of a very detailed calculation, and found ultimately for Mr. Horcher that the standard had been breached. The Court of Appeal affirmed that, and the High Court disagreed. They looked at Dr. Baston's qualifications, his experience, his training, and there was nothing disclosed either in his qualifications or in the report itself which would qualify him to make estimates of the production of silica dust or the exposure of silica dust within a certain environment. So that whole line of evidence fell over completely. Now, happily for Mr. Horcher, the judgment was upheld on other grounds because there was some evidence that had been put in about the time that from inhalation of silica dust to the time when the disease arises. And so, fortunately for him, that failing on the evidence didn't undermine the judgment that he received at first instance in his favour. But it does illustrate the danger when you're relying on something that your expert purports to give an expert opinion on, and there wasn't this testing done of whether the expert really had the expertise to give that opinion. And were it not for this alternative basis, Mr. Horcher would have lost and presumably would have had to pay his employer's costs of the whole process. Now, my next golden rule for undermining evidence and making it difficult for your expert is to give the expert oral instructions, drip feed them documents over time, and make sure they confer together with lay witnesses. So all of this goes to ensuring that your witness doesn't have the opportunity to clearly and succinctly state out the matters on which the opinion's based. So most jurisdictions have either a code of conduct or they have rules or a practice note which sets out the ways that the expert needs to give their evidence. It'll generally say things along the lines that experts need to be independent, they're there to assist the court, not to act for parties, they need to state all their assumptions, they need to expose the path of reasoning, all the things which really match up with what the Evidence Act requires. So the first thing you generally need to do is to provide a copy of the code of conduct or the practice note to your expert. Make sure they understand what they're doing. Give them a clear set of written instructions. There's plenty of cases where experts under cross-examination will be asked about their instructions, and if everything has been conveyed in writing, it's the easiest possible way to avoid any query that the expert's taken into account things that they shouldn't have. They say, all my instructions are in these letters, I've annexed them to my report, and that's the end of the matter. It can't really go any further. You give them a list of the documents that you're providing with them. Make it easy for the expert. So they might miss something when they're producing the report. Sometimes they're under time pressures as the deadline looms. If you've given your expert a set of written instructions and a list of the documents that they've been provided, all they need to do is annex that to the report, and that's their job done on that point. So all of this is laying the groundwork so that your expert has got a solid basis for the opinion that they then give. They can say, these are the assumptions, these are my instructions, and then they disclose the reasoning from those assumptions to the opinion. Another way to ensure that this is done is to quarantine your expert. So don't let them sit down with the lay witnesses and start talking about what might or might not happen or have happened. The expert should receive their instructions from you and keep it that way. Now, there is a role for what's often called dirty experts, and if you're dealing with a case that can bear the cost of it, it's often useful to have another expert who you can put all these sort of things to that you don't want the expert giving evidence to necessarily be informed of. So you can ask your dirty expert, well, if the evidence turns out this way, what effect is that going to have on the opinion? You can get your dirty expert to go through the other side's expert statement with you in detail, and you can put a whole lot of matters in front of your dirty expert which will never see a witness box. Your clean expert is the one who you just simply set out the assumptions, provide the relevant facts, the relevant documents that you want them to draw their opinion from. Another thing I generally do is, in giving the assumptions to the expert, it's really critical that the first step in the process is to talk to your lay witnesses and understand all your documents. Bearing in mind that your expert's opinion is of little weight if the assumptions that they rely on aren't borne out by the evidence. So the starting point is, what's the evidence going to be? Talk to your lay witnesses. Where you can, find corroborating evidence or documents which are going to support that version of the evidence. Give the bare minimum that you need to give to the expert so that they can give their opinion, and invite the expert to come back to you if they need more information. But focus on what will be proven at trial, and have the expert generate their opinion based on what you think will be proven at trial. Nothing's foolproof and things fall over and witnesses forget things, but if you at least start with what the witness is telling you in conference and what the documents show, then you've got a much higher likelihood of getting to the expert opinion and having it well grounded in proven facts. Now, an expert opinion won't be inadmissible if the facts don't match up exactly to the assumptions in the expert report, but it goes without saying that the further the facts are from the assumptions, the less weight the court's going to give to that opinion. There was a decision of Justice Dickson recently in Hudspeth and Scholastic Cleaning and Consultancy Services, and this case has got certain unhappy twists which I think are still unfolding, where an expert and some solicitors have been asked to put some evidence before the court about why they weren't in breach of their overarching obligations. But at an earlier stage in the case, there was a ruling on the admissibility of some expert evidence. Mrs. Hudspeth was a school cleaner. She was cleaning a boy's toilet and she slipped on the tiled floor which had some spilled watery liquid soap on the floor, and she sued for physical and psychological injuries. She sued the manufacturer of the soap dispenser, she sued her employer, and she sued the Roman Catholic Trust who ran the school. And she called Dr. Cubitt to give evidence. He gave evidence that the risk of soap on the floor from vandalism should have been better controlled. He didn't explain how that opinion was grounded in fact or on any of his expertise, which, and I haven't noted here, I think he was I think he may have been an engineer. And so Justice Dickson said, I'm not going to take that into account. He gave some evidence that the floor in this bathroom didn't comply with the Building Code of Australia's standards for ramps, walkways and landings. He didn't give any evidence about why that particular standard should apply to a bathroom floor, and again, that was ruled inadmissible. He also gave some evidence that the probability of a fall would have been lower if the floor had complied with that walkways, ramps and landings standard. But he didn't test the coefficient of friction of that kind of floor when it had liquid soap on it. He did conduct tests on the bathroom floor. And so again, Justice Dickson said, well, there's no, firstly, that for a large part of that, you don't have the expertise. Secondly, you haven't set out the factual assumptions on which that opinion is based. You haven't conducted the necessary tests. And so a large part of that evidence was ruled inadmissible. And there may be some interesting judgments yet to be published on this issue in relation to a third expert report that was prepared by a different witness, which emerged late in the cross-examination and was said might have breached the expert and the solicitors and counsel's overarching obligations to the court. So worth keeping an eye on on what evolves in relation to that. It's really important to remember that everything you put before the court, and this is something that Sam touched on earlier, and the same applies for expert evidence, it's a tool of persuasion to try and persuade the trier of fact that your case should be accepted. So when a judge reads an expert report that's full of jargon, that includes a whole lot of unstated assumptions or reads more like an academic paper than something which might illuminate the layperson, it really doesn't help. And there are some experts who fall into the trap of thinking that they're writing for a journal. And as to a matter of style, there's no difficulty in suggesting to your expert that things could be explained more clearly, or things could be explained better so that a layperson understands what's being said. Because remembering that sometimes experts forget because they might be looking at the other side's expert report, they might think they're responding to that rather than informing the court. And so it's useful to remind experts that their task is to try and illuminate the issue for the court, and the best way to do that is to spell everything out in easy to understand language, to try and minimise the use of jargon, and to try and spell out all of the assumptions which might be implicit to anybody in the industry, but would not be understood by somebody outside the industry. The court has a general discretion to exclude evidence under Section 135 of the Evidence Act if it would be either take up an undue amount of time compared with its probative value, or if it would be confusing or misleading. And if an expert report is prepared that really doesn't assist because it's mired in jargon, then you run the risk that it might be excluded under Section 135 of the Evidence Act. So it's something to bear in mind, and just to nudge your expert to try and dumb things down for those of us who aren't in the industry. The final point I've made in the notes is the golden rule to ensure that your expert loses all credibility whatsoever and will never be invited to appear in a court again, is if you don't like your expert's conclusions, change them. And as obvious as it might seem that that's the worst possible thing to do, it happens. And I was lucky enough to be involved in a case. I think it was the first trial I ever had after coming to the bar, and precisely this happened. It was a case dealing with the protection of forests in Tasmania, and Forestry Tasmania was effectively trying to present a case that logging in certain areas wasn't going to have any harmful effect on the broad-toothed stag beetle. They called the world expert on broad-toothed stag beetles, Mr. Meggs, who flew out from Canada, unhappily arrived, sat in the witness box for 2 days, had some gastro at the time, so the experience was already unpleasant enough. But before he arrived and before he filed his expert report, there had been communications between Mr. Meggs and Forestry Tasmania, which came out in cross-examination. And the judge wasn't impressed. Justice Marshall said this about Mr. Meggs. Under cross-examination, Mr. Meggs was frequently evasive. That might have been just because he was running to the toilet, I'm not sure. And he appeared to me to be much more of an advocate for the cause of Forestry Tasmania than an independent expert. I accept the applicant's submission that Mr. Meggs was a partisan polemic and a so-called independent expert. The worst aspect of Mr. Meggs' lack of independence was his preparedness to alter his affidavit evidence based on suggestions by senior employees of Forestry Tasmania. Mr. Meggs gave evidence that his affidavit received peer review from the following people. There's 5 people at Forestry Tasmania. Mr. Meggs gave evidence that he changed no matter of substance in his affidavit in consequence of this peer review process. That evidence is false. Mr. Meggs did change matters of substance as a result of the peer review process. He excised parts of his draft affidavit which were helpful to the case of the applicant but unhelpful to Forestry Tasmania. At the urging of an officer or officers of Forestry Tasmania, Mr Meggs deleted the following sentence. The longer the status quo of conservation management for this species is maintained, the higher the risk of extinction to the species based on current knowledge. Mr Meggs denied deleting the sentence because the Forestry Tasmania employees wanted it deleted. I do not accept that denial. And in fact, in cross-examination, we had drafts were produced which had markups from Forestry Tasmania suggesting perhaps you could delete this sentence or perhaps you could delete that paragraph. He concluded that the manipulation of Mr Meggs' evidence is regrettable. So I suspect Mr Meggs will never give expert evidence again. And Forestry Tasmania went on to lose that case as a result of that and some other expert evidence issues which didn't play out particularly well for them in the judge's eyes. So if you don't like your expert's opinion, you don't have to call them. But certainly don't ever try and change them, because you can bet that there will be a line of questioning in cross-examination that will come out, and when it does, it's just dynamite, and really nothing the expert says after that is likely to be accepted if they've been willing to change their opinion based on your suggestion. Now, there's just a couple of final matters that I wanted to touch on before I finish up the questions. There is a new division, part 4.6 of the Victorian Civil Procedure Act, which deals with expert evidence. Largely it reflects things that are already in the various rules of the courts, but it's worth having a look at. There's, the courts now have a power to require experts to disclose their retainer terms and conditions, and there's a few other things which are generally picked up by the rules. I have Jane Salverson from Minter Ellison has produced a checklist which is, I find, really useful, and it was presented as part of a commercial court seminar. It's a checklist for expert evidence dealing with the different jurisdictions and the requirements that you have to meet. If anybody would like a copy of that, I'm very happy. If you email me, I'll send you the link to it. And I've also got a basic checklist that I've prepared, and what I might do is to give that to, together with a paper that I prepared previously, I'll give that to Michael to put up on the Greens List website. So perhaps you might either email me and I'll send you a copy, or I'm sure the Greens team will have it up fairly shortly. So that's everything that I wanted to say, and perhaps we can move on to some questions either for Sam or for me, or for Paul.
Thanks very much, Travis. Well, what a lousy chairman I am. It's nearly 10 to 9. I know that a lot of people like to leave at 1:45, but I'm sure that there are some questions that people might like to ask our two presenters, and Brett has a microphone. So can I invite questions from the floor? My questions about the stag beetle can wait for another time, but are there any questions that people might like to ask Sam or Travis? It's a bit like an auction where no one's prepared to make the first bid. Great.
Hi, my question is for Travis. What is your opinion regarding the discoverability of communications to experts you do not ultimately obtain a report from?
Is this working? Yes. A document which is prepared for the purpose of legal proceedings, which I assume this is, has client legal privilege over the document. That's, as a matter of principle, that's waived once the expert report goes into evidence. So if it never sees the light of day, and if it's so that it doesn't form part of the basis of evidence, and if it's a document that's been prepared for the purpose of legal proceedings, then you can claim privilege over it.
Are there any other questions? Ross, would you like to?
Yes, Paul. It hasn't actually been touched on, and it's perhaps not exactly on the topic of this morning's session, but it does come to your point about management of witnesses. if, for example, you've got a witness who's been under cross-examination for 5 or 6 days and they're feeling jaded and worse, with the rule about not being able to talk to them when they're under cross-examination, to what extent can you communicate with that witness?
Can I answer that? That point has arisen in a trial that's presently being conducted in the Supreme Court, where at least 2 of the witnesses were in the witness box for 5 or 6 days. And it was becoming apparent that after the 3rd or 4th day, at least one of those witnesses was becoming pretty tired. He was a man close to his 70s, certainly late 60s, and the court was sitting extended hours, and the only thing that I could do was to ask if the afternoon sessions could be broken up so that that witness could have a break during the course of the afternoon. There was also a break during the morning session. So that, to some extent, lightened the load. But the only... I had to ask permission from the court to speak to the witness about his own travel arrangements, because he was an interstate witness. He had expected to be in Melbourne for 3 or 4 days. He found himself being required to come back for a second week. So I spoke to my opponent and raised it with the court about talking to the witness about his arrangements, but that was as far as one could go. But of course the witness wanted to ask the judge, how long am I expected to be here? I had planned to go overseas next week on business. And so there was, some reasonable common sense latitude given to enable you to speak to that witness while he was under cross-examination. Of course, you're always entitled to speak to a witness after the cross-examination has finished in order to obtain instructions before you commence re-examination, if that's what you want to do, which is sort of a slightly different point. But that's a good question. That really creates difficulties for witnesses who are in the box for a long time. But does anyone else have experience of that situation? I was going to ask a construction lawyer, Paul Woods, how he prepares witnesses in building cases where you've often got a project manager that's been there when the ground is cut till the installation of the panels and the finishing off, where in building work, what happens on a particular day over the course of a project that might last 3 years or so might be important. How do you go about preparing witnesses in that situation?
Paul, it occurred to me while Sam and Travis were speaking that when I was about 5 or 6 years ago, I had to do this for a project manager on a civil construction case, the building of a pipeline, and his statement was about 200 pages long. It was in an arbitration, and I had to interview him for about 2 weeks, full time, and it was very frustrating for him. He was an outdoors person, and there were times when I was looking across the desk at him, asking him very mundane questions from his site diary about what he was doing on a particular day, where they'd got to, why they made decisions to move around the site. And he was so frustrated and bored that at one stage he got up and walked around the side of the desk and looked at my laptop, and he said, "I didn't trust you, I thought you were checking your emails and not listening to me." But that was literally 2 weeks of hard slog, and he didn't like me at the end. He was sick of the process, and it really made me worry about, this was an arbitration, it made me worry about his demeanour when it came time for the hearing. And I remember asking my colleagues at the time in the barrister if there is any other way of doing this. Is there some other, because this feels like it's going to damage the case for reasons not to do with the merits at all or the witness, but there wasn't.
And was that witness still employed by the client?
Yeah, he was, and that was another frustration because this was a regional civil contractor that made its money by having its experienced people on the site doing the job for them. So effectively one of their other projects had to shut down while this fellow, Martin, was sitting with me. And there's nothing you can do about that. I couldn't explain to the client why his business was not making money while he had his star witness with me. I'm not offering any solutions, but construction cases are peculiar because usually there is so much documentation and so much minute evidence that needs to be proved about a day-to-day project and following a program through to try and prove a delay, for example, that those witness statements are very, very long, and it's usually a blessing if the judge or the arbitrator says that they're going to dispense with written statements and they'd rather do it orally.
Thanks, Paul. Jeremy Brand, one of the difficulties of sitting in the front row is that you sometimes get exposed to questions, but I wanted to ask you, what's your experience and how do you deal with a witness who might no longer be employed by the client and where the witness really does not wish to become involved, but that witness's evidence is crucial? How do you go about encouraging the witness to participate?
That's actually quite a difficult question to answer, but I think very broadly, obviously if a witness doesn't want to cooperate, you can subpoena them to give evidence, and that has its benefits and detriments. But I haven't had a witness who's refused to participate. Actually, I know it sounds extraordinary. I think you start with the proposition that everything's changed. There's this dichotomy or problem that we have, that we're in an adversarial system, but the community doesn't like it. We see that. And we see that in the rules that are going on and the changes. So we've got the practice rule, and that sets out the practice note in the Supreme Court, that sets out the intervention that judges can undertake, that they're constantly doing. I point these things out to witnesses. I make it clear to witnesses that they are to give evidence based on their experience. They're not advocates, they shouldn't be. And in respect, it was interesting what you said about expert witnesses and the dirty, or what I think might be better called a shadow witness, that under the practice rule, it actually says that you should advise the court in the particular list that it's relevant to at the earliest possible opportunity if you're going to call an expert witness. I'm pretty sure it says something along those lines. So you can no longer deploy expert witnesses at a time of your choosing. If you know you're going to call that witness as an expert, then you ought to tell the court up front. And that's a big change, and I think a lot of people aren't doing that even now because they don't recognise it. So I think that's really important. And maybe finally that I've sat through, and in terms of coming back to your question, I just think being very straightforward with witnesses and explaining to them that you're not seeking to get evidence from them merely to support your client. You're trying to get to the justice of the truth of the matter, even in an adversarial. It really gets them over the line. However, I've sat through many conferences where, and particularly barristers, I'll say, have said to expert, or not expert witnesses, they give a summary, and so do we lawyers, solicitors, about what they can expect in court, including that they should look at the judge, not the person who's examining them, and so on. I was recently involved in a case in the family court, which is very unusual for me, but it had commercial aspects, where the judge said to a witness, who was a star witness because of how badly they were doing, you sit up in your chair, look at me when you talk, and this kind of stuff. And the barrister on Active for Us was wild about it because they felt this was coaching. In the end, the judge did a great job, but is it any better, I wonder, and I'll put this forward for practitioners to tell their witnesses, look, when you're going to court, this is what's going to happen. Look at the judge, talk to the judge, don't get involved. Or is that actually now overstepping the boundary? I suspect it is, but...
Well, that's a very interesting question and possibly one for another seminar. I must say I'm in the old school of encouraging a witness to have a conversation with judge, which necessarily involves a witness looking at the judge. But that's the topic of coaching a witness, which Sam dealt with, is very interesting, and drawing the line between the proper responsible preparation of a witness for trial and coaching is easy to speak of theoretically, but it's mighty difficult to respect the divide in practice, I think. But we can perhaps deal with that later. I think I'm going to now need to bring the seminar to an end, and I'd invite you to thank our two presenters, Sam and Travis, for their two papers this morning. Thanks very much for coming to the seminar. Have a good day.